What's going on, Houston? This is criminal defense attorney Corey Roth coming to you from my office deep in the heart of Houston, Texas, Montrose in particular. This song in the background is Dreams, covered by Jaguar Dreams of Dreams by Fleetwood Mac. And it's important to my topic today in criminal defense in general. Just take a quick listen. So you say you want your freedom. Who am I to keep you down? That's kind of the role of the judge. Who am I to keep you down? Well, judges have an obligation, in misdemeanor cases at least, to determine probable cause. Now, this topic is about probable cause because today I had a judge find no probable cause in 3 cases of mine. I had 3 more to go through that I'm convinced he would have found no probable cause on. So what is probable cause? Probable cause are facts and circumstances that leads a reasonable person to believe that a particular person has committed a particular crime. It is the lowest, scintilla of evidence is the lowest, but probable cause is the lowest standard of proof that we see really in courtrooms regularly. Probable cause, preponderance of the evidence, more likely than not, clear and convincing, and then beyond a reasonable doubt, right? Beyond a reasonable doubt. But just in order to be charged with a crime, in order to get a ticket, in order for your case to proceed to trial, there has to be a finding of probable cause or a waiver of a finding of probable cause. So if an officer pulls you over and writes you a ticket, he believes that there's probable cause. That's just a Class C misdemeanor in Texas. For a felony, an officer will arrest you, call the police, call the prosecutor in Harris County, for example, say, this is what happens. The prosecutor will say, I believe there's probable cause, and they'll file a complaint, and then they'll take that case to a grand jury. A grand jury is 12 members of the community who meet in secret to determine whether there's probable cause to charge you with a crime and for your case to proceed to trial. But in a misdemeanor, it works a little differently because misdemeanors aren't so serious. The state doesn't believe that you should. That any misdemeanor case really requires the community to act as a check on law enforcement, including the district attorney's office. But as a defendant, as a defense attorney, you have the right to ask the court to make a probable cause determination of a probable cause hearing. You also have the right to waive that hearing. Sometimes I will waive that hearing if I read the summary, the factual summary, that the prosecutor is going to read to the judge to make the probable cause determination. If I think that there's clearly probable cause and that statement isn't inconsistent with my client's statement, then we're not going to waste the judge's time or burn through my credibility, because that's the most important thing your attorney has with a judge, with a jury, with prosecutors is credibility. So we don't want to waste anybody's time. So, probable cause, facts and circumstances that would cause a reasonable person to believe that a particular person committed a particular crime. So today I had 3 cases, 2 clients that I approached for probable cause on. I did not believe that there were facts or circumstances that were alleged that would amount to a crime. And if they were alleged, they did not support the allegations as they were charged in the charging instrument, the information. The facts have to support and prove what was alleged in the charging instrument, what's called the information. So one client, he was charged with terroristic threat and failure to identify. Failure to identify actually as a fugitive, which bumps it up from a Class B misdemeanor to a Class A misdemeanor, making him susceptible to being punished by up to a year in county jail and a $4,000 fine. And the officer claimed that my client did not identify himself because he didn't give a birth date and he did not give his complete accurate name. Even though he gave his 2-part last name in the correct sequence, he gave a first name that was similar to his actual first name. And the judge found that there was no probable cause. I agreed that there was no probable cause. Otherwise, I wouldn't have made the motion to find no probable cause. Because I think the officer could have made a mistake in interpreting or hearing my client. Another thing was that even though the officer alleged there were no dates, or that my client gave inaccurate dates or did not refuse to give dates, it wasn't alleged in the charging instrument. So maybe if the prosecutor had alleged in the charging instrument that the manner and means by which he violated that law was either by not giving the accurate name or by not giving an accurate birth date, the judge probably would have found probable cause on the second one, right? Not giving an accurate birth date. But that wasn't alleged, so the judge found no probable cause. On the client's other case, terroristic threat. Terroristic threat, just kind of generally, is making threats that scare a person, that put them in fear. Now, it needs to put them in fear of imminent bodily injury or harm. In this particular case, my client allegedly made a threat of imminent bodily injury or harm to the complainant's property, but there was no imminence. There was no threat that he was going to do that anytime soon or immediately, or that he was capable of doing either of that. So there's no probable cause to believe that he committed the crime. Crimes are made up of elements: date, location, identity of the defendant, sometimes who it was committed against, and finally, what was said or what was done, the act, and sometimes the mental requirement, the mental element, the mens rea. And the judge agreed with me that there was the imminence element was not satisfied. No probable cause. So in the final case today, it was an evading case. Evading is also a Class A misdemeanor if it's on foot. Evading on foot can be bumped up to a state jail felony if the accused has prior convictions for it. But this client was accused of a felony burglary and evading, and supposedly he ran from the scene of the burglary. Yet there were no allegations in the factual summary, the dim summary, that my client ran from the police, that the police commanded him to stop, that my client knew they were police officers making a lawful command. So there was no crime. That one was actually quite shocking because it was just completely left out. So what happens when a judge finds no probable cause on a misdemeanor? On a misdemeanor, when a judge finds no probable cause, the state has two options. They can either dismiss the case, or they can actually take it to a grand jury for an indictment. They rarely do that. Sometimes they do if the facts are particularly egregious. I don't anticipate that'll happen today from today's cases, but it's possible. So, probable cause. What is it? Facts and circumstances that would lead a reasonable person to believe that a particular person committed a particular crime. That's what's needed to get you to a trial. Maybe I'll discuss probable cause, how it works in felony cases on a future video. My name is Corey Roth, Coryyroth. I'm a criminal defense attorney based in Houston, Texas. I practice throughout the state. I get excellent results, a lot of acquittals, not guilty verdicts, a lot of dismissals, no bills on grand jury packets, motions to suppress, I win them quite often. In fact, I can't think of one that I've lost. I can't think of a trial that I have lost where it was my client, where I was the first chair. And I've tried about 20, 25 of those. Give me a call, 832-819-5290, or shoot me an email, Corey@attorneyroth.com, or just visit my website, www.attorneyroth.com, and that's spelled ATTORNEYROTH.com. Take care, everybody. If you want your freedom, give me a call.